3, 2, 1, start. He wanted to have photostat copies of all the documents relating to these two references from his office, and there was office nothing found in the file. Stop. He was wanted to have the copy of the opinion tendered by the public prosecutor regarding filing of an appeal against the order of this court. He further wanted to know as to who was responsible for taking action against persons on the basis of observation made in paragraph 18 of the said judgment. It was written in paragraph that their office had written many letters along with annexures. If they do not have any such records in their office, they were asked to act in terms of the RTI Act. On receipt of the said requisition, the petitioner's office informed that they were not in a position to inform the second respondent as he was not entitled to get such information. In respect of the opinion tendered in respect of any case, they are not available under the provisions of the Act. Since the second respondent approached the first respondent, the Commission informed the information officer of the petitioner's office to furnish such information as sought for by the second respondent. When the second respondent failed to get any information, he filed a second appeal to the first respondent. Further, they had already informed that the opinion tendered by their office cannot be divulged to the respondent number 2. It was further impressed that the relationship between the public prosecutor and the government is one of lawyer and client relationship. Under section 126 of the Indian Evidence Act 1872, it is privileged information and there is a bar for divulging such information. The Commission issued the summons to appear before the Commission along with the original records for further consideration. The said date was postponed at the instance of the respondent. In the meanwhile, the petitioner filed the present writ petition and it was admitted and an interim stay was also granted. After notice, the matter came to be posted. No barrister, attorney or pleader shall be permitted to disclose any communication made to him in the courts unless with the client's express consent, and he shall not state the contents or condition of any document with which he has become acquainted in the courts and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course of such employment, provided that nothing shall protect from disclosure of any such communication made in furtherance of any illegal purpose or any fact observed by any barrister, pleader or attorney showing that any crime or fraud has been committed since the commencement of his employment. It is immaterial whether the attention was not directed to such fact by or on behalf of his client. He holds a public office and information available with his office is in the public domain. It is for the competent authority to be satisfied as to whether disclosure was in large public interest. The obligation stated continuous after the employment has increased. Stop.